Yes.
Lord,
Yeah.
I was allowed to make a mention for items 4, 5, and 6. The department and the contractor are in the process of negotiation. If the matter can kindly come up after 6 weeks.
4, 5, and 6.
Yes, my lord.
4, 5, and 6 mention has been made by the learned counsel for the petitioner, Mr. Cynthia Younger, to list the matter after 6 weeks, as some negotiation is going on between the petitioner and the department. So,
Thank you.
learned senior government advocate Moim Chin is present. List the matter after 3 weeks.
6 weeks.
Oh, 6 weeks.
Yes, my lord.
Oh, okay. In the first one also for 6 weeks.
Much of them. No.
Okay. Yes.
Yes, Your Lordship. I beg to mention hearing item number 12.
Hmm.
Lordship, I need some further time for preparation. Sorry for wait time.
You're the petitioner. Learned counsel for the petitioner. She such and such. Your name has prayed for how much time?
4 weeks time.
4 weeks time. List the matter after 4 weeks for hearing. Learned counsel for the government. Learned your name. Pichano Tan is present. Yes. 4 weeks.
Lordship, I also like to beg to mention item number 16
Item 16.
on behalf of petitioner AG Song. Can we list this matter after 3 weeks session?
After 3 weeks.
Lordship.
Okay, mention has been made on behalf of Mr. M.T.M. Song, learned HNAG by MS Pichano, learned government advocate, to list the matter after 3 weeks. Stop. List after 3 weeks, just prayed for. Who's appearing for petitioner? Item 16. Oh, this is the matter which was listed yesterday. Younger Wati, where is Younger Wati? Oh. M.T.M. Song is praying for 3 weeks. They have not filed, you have not filed counter affidavit, okay, in this case. Yes, 3 weeks.
Lordship, I also like to beg to mention item number 31 on behalf of Tipapong. Can we list this matter after 2 weeks?
Item 31.
Lordship.
Is this from that mediation?
Lordship.
Wait, no, for this, just wait for some time, okay? We will pass necessary orders.
Actually, Lordship,
Uh,
this matter was wrongly listed.
Oh.
It was listed on 18/7/2025 and was adjourned for 2 weeks. However, it was wrongly listed.
No, we have just instructed the registry to list everything so that if there is any scope for mediation, we will refer it. Otherwise, it will be kept in the normal. Okay, so we'll see later. Don't mention anything from this mediation section.
Lordship, I would like to.
Yes.
Lordship, application for the
Item
13.
13.
Yes, Lordship, here we are yet to file a reply.
Reply.
Yes, Lordship.
Okay. Third learned counsel for the petitioner, MS such and such. 2 weeks. Who prays for 2 weeks' time to file a reply to the counter affidavit? Oh, you are for the respondent.
I'm for the petition.
You want to reply to the sole respondent, okay? Who has prayed for 2 weeks' time to file a reply to the counter affidavit filed by the sole respondent. But government is also there, also a party. So you want to file a reply to the counter of the private respondent.
To the yes, or private respondents.
Okay, then we'll just say respondents. Reply to the counter affidavit of the respondents, okay? List after 2 weeks. Yes.
Wait, please, Lordship.
Yes.
Lordship, I beg to mention item number 7. Here I need to file affidavit in opposition, so kindly can be choose time to file affidavit in opposition. And for respondent number 5.
Okay, learned counsel W. Marhus appearing for respondent number 5 has prayed for
3 weeks.
3 weeks' time to file counter affidavit. List the matter after 3 weeks. The government has filed. Okay, anyway, you also filed them. 3 weeks.
Right.
Yes.
Please, Your Lordship.
Yes.
I'd like to mention item number 8 and 9. Here we have received the affidavits from the state as well as the private respondents, except for respondent 9 in WPC 194 of 2024. If sometime may be granted to us to file our affidavit with like.
89, learned counsel for the petitioner, MS such and such, has prayed for
3 weeks.
3 weeks' time to file a reply to the counter affidavit filed by the respondents. Prayers allowed, list the matter after 3 weeks.
This Lordship.
Yes.
Lordship, I would like to mention item number 43 and 43 from the hearing list. Your Lordship, on the last occasion, the petitioner has withdrawn his wakalat nama. So we have filed our wakalat nama today.
You just wait for some time because these matters have been identified for mediation. So if there is any scope for mediation,
Lordship,
we'll
item number 42.
42. Yes, this whole cost list, this one. Yes.
Lordship, Lordship, I beg to mention item number 11
Item 11.
on behalf of petitioner N.J. Impimson. Lordship, can this is better after 1 week.
Lordship, this was possible today, and similar cases has already disposed of yesterday. That's because the additional he was not present, so it was left unpaid.
Hearing item 11.
Mission.
No, she's mentioning hearing item 11.
Which one? Is it here or this one, no? It's for hearing item number 11.
You're mentioning WPC 65. WPC 65, isn't it? Admission item 16 was yesterday's. That one already 3 weeks has been taken.
No,
Supposed to be taken up today.
It was supposed to be taken up today, but the brief is with Mr. Im Tim Song. And he's not present. What's his problem? He's out of station. No.
You should have taken the consent of the parties.
Lordship, is the spirit of Lordship.
If they want to extend time, worship, we have no objection. But it's consent should be taken.
Consent, you didn't take the consent
No.
initially before mentioning.
Lordship is the spirit of Lordship.
We
Yeah,
understand.
but at least inform the other side before mentioning.
Since there are other similarly that matters, and yesterday I made a submission regarding the legality of the SRD. These are the judgments law.
Yes, just wait. Okay, then item 11, hearing, yes. Item 11, no objection.
If this, what you said.
No, here also Im Tim Song is appearing, you're saying.
Mr. Moon.
Okay, then. Take it. All from this list first, no motion. All from this list first, then we'll finish this list, then after that mediation.
From the supplementary cost list for motion, item number 14.
May it please, Your Lordship.
Yes.
Lordship, this review petition is filed for reviewing the order dated 24/4/2025. That is annexure 3, page 25. And Lordship, the operative part is at page 26.
Annexure 3.
Yes, Your Lordship. And the operative part is at page 26. Lordship, the second paragraph. I may be allowed to
No,
read.
this is motion item 14, WPC 126 of 2025.
All right, then my mistake. My apologies.
Mm.
This Lordship.
I think similar matter like yesterday's.
Yes.
Yes.
Where the amount is 22 lakhs, 55,000,
Uh-huh.
424 for the financial year 2016-18, Your Lordship.
Why was it filed separately?
Your Lordship, this amount is after the implementation of GST.
Oh,
2017.
okay. This petition under Article 226 of the Constitution of India has been filed by the petitioner, praying for release of the undisputed dues amounting to rupees 22 lakhs 55,424 to the petitioner for repair / replacement of government vehicles and supply of spare parts at the office of the Superintendent of Police, Mon Nagaland. Stop. Learned Senior Government Advocate, Mr. N. Nangami, accepts notice on behalf of all the respondents. Stop. On the next date, list the matter after 4 weeks. On the next date, the Learned Senior Government Advocate shall obtain instructions as to whether these pending bills are undisputed, and an effort will be made to dispose of the same. The Learned Counsel for the petitioner shall supply extra copies of the writ petition to the Learned Senior Government Advocate. We can take it up together, no? Yes. You call that. I'll check this one.
For motion, item number 1.
Lordship,
Yes.
Please, Lordship. Lordship, this review petition has been filed for reviewing the order dated 24/4/2025. That is, Lordship, Annexure 23, page 23. Annexure 3, page 23. And the operative part is at page 26. Lordship. I may be allowed to read. Second
Yes.
paragraph. This IA has been filed by the applicant with a prayer to restrain the respondent number 2 from holding the upcoming DPC and for staying the promotion of any incumbent who is junior to the writ petitioner. However, today when the matter is called up, Mr. ZN Learned CGC has produced a copy of the written instruction dated 28/2/2025 to submit that the DPC for the year 2024 has already been convened and eligible persons have already been promoted and they have also assumed their rank, and therefore the IA has become infructuous. So, Lordship, in view of this IA was disposed of. However, Lordship, my prayer in the IA was that to refrain the respondent to conduct DPC for the year 2025, not 2024. But they have misled this honorable court and they have filed a they have placed on record 2 letter dated, that is, Lordship, that is at page 27, Annexure 4. It is intimated that the petitioner has filed the sub IA before the Honorable Gauhati High Court, Kohima bench, Nagaland, seeking stay on the upcoming DPC. However, DPC for the year 2024 has already been convened and eligible personnel had already been promoted and assumed their rank. Therefore, sub LA has become infructuous. Moreover, at present, if any stay granted on the same, this will adversely affect a lot of personnel of this force. However, Lordship, in my petition, I have categorically mentioned that is annexure 1, page 21, and kindly come to Lordship, paragraph 7 of my IA application. I have categorically stated, Lordship, I may be allowed to read paragraph
Where is
5,
that?
page 17, annexure 1.
Page 17.
Yes, Your Lordship. Annexure 1, page 17, paragraph 5.
Annexure 1, page 17. Page 17 is internal page.
Yes, Your Lordship. That is annexure. The IA application which I have filed before this honorable court, and it was disposed of.
Oh,
And I have enclosed this. Yes,
it's an annexure. So which para?
paragraph 5. Paragraph 5.
Okay, yes.
I may be allowed to read that it is
Yes.
apt to mention that before the petitioner could prefer the instant writ petition before this honorable court, the respondent number 2 in the month of March 2024 has promoted one of the incumbent to the post of Subedar Major, though the petitioner was senior to the said incumbent. That it is respectfully submitted that in the month of January, the respondent number 2 will hold a DPC for promoting some incumbent to the post of Subedar Major Saipan, and the petitioner anticipates that in the month of March 2025, promotion order will be issued by the respondent number 2. Lordship, here, Lordship, I have categorically mentioned about the DPC for the year 2025 month March, Lordship. But they have misled this honorable court and they have produced these two letters, Lordship. And accordingly, my IA was disposed of.
Here you're praying
And
for
besides,
review.
Lordship,
Yes, you're praying for
yes,
review.
and besides,
But
yes, Lordship. And
the
besides, Lordship, my instruction is that the respondent has already conducted a DPC for the 2025, and they have already promoted my juniors. My instruction is that. So, in the light of that promotion order, this review petition has also become infectious. And also, Lordship, I beg to submit that I have filed a review petition on time, but the matter was not listed. Before they could have issued the promotion order or conduct the DPC,
we will issue notice on this because there are only certain conditions under which a review can be filed. So that those conditions have to be fulfilled. So we will just issue notice at this stage. Is anyone accepted notice? You have received copy. Yes. Any objection?
Yes, I have objection to my lord, this is regarding for APA, marking of APA. So that
No,
now
they are saying that you have given some wrong submissions, no?
no, my lord, according to the instructions of the
Mm.
my funds, I have submitted that.
In that case, we will issue notice. You file your objections if so advised. Okay. The present review petition has been filed by the petitioner praying for review of the order dated 1 minute, okay? Order dated 24/4/2025, passed in IA Civil 4/2025. So Learned CGC ZN Muli has accepted notice on behalf of the all the respondents, I think, no? No. On behalf of the respondent number 1 to 3.
Yes, ma'am.
On behalf of the respondent 1, 2, and 3. What about this 4 to 7?
ma'am, Lordship, they are the pro forma respondent, Lordship. They are the pro forma respondent, so their role is not required. They are the private respondent, Lordship. Since they were the party in the main writ petition, so I just implemented them as a pro forma respondent.
Okay. So ZN Muli has accepted notice on behalf of respondents number 1, 2, and 3. Hence, no formal notice is called for. Stop. List a matter after 4 weeks. In the meantime, the Learned CGC shall file his objections if so advised.
Highly advised.
Yes.
For motion, item number 15.
This one is 15. 15.
Please, your lordship.
Yes.
Lordship, the petitioner was appointed as work charge Mali on skill pay, and she was appointed on 19 October 1994. And she was serving about 30 years in the department under the establishment of executive engineer, PWD housing in Kifri section. And her service was verified and recorded as genuine from time to time. Her service was verified and recorded as genuine. And her salary was also revised. And then she received her salary till June 2021. Thereafter, she did not receive her salary. And thereafter,
Till June 2021.
2021, Your Lordship. And then after that, she received the show cause notice, which I've annexed in Annexure 21, page 58. Show cause notice dated 5th October 2024, stating that her service has been found to be irregular and she falls under the category of N subcategory. But no mention has been given as to why her service is irregular or what this N subcategory constitute. Then she filed her reply, which I've annexed in Annexure 22, page 59. And in the reply, she has mentioned all the details about her appointment, verification, and personal details. And this reply was not considered. And thereafter, by notification dated 6th November 2024, she was terminated from her service. And the reason given was that her service is irregular and placed under N subcategory. And no detail mentioned about what this irregularity consists of or what this N subcategory consists of. So without assigning a proper reason for her termination.
So you had served for how many years?
For about 30 years.
2 years.
She was appointed in 1994 October.
1994, yes.
So 2024 October, she has already completed 30 years.
While still serving on work charge basis.
Yes, Your Lordship. And she was to be regularized, and instead of considering her regularization, she was issued a show cause notice and then thereafter terminated from the service. Lordship. And that is the reason why the petition is before this honorable court.
The present petitioner has approached this court praying for quashing and setting aside of the impugned notification.
Page number 16.
Wait a minute. First, impugned show cause notice. Impugned show cause notice number ENC/PIMS/WC.VAR/CORR. You just see from the prayer portion, okay? Such and such, dated 5/10/2024, issued by the Engineer-in-Chief NPWD Nagaland Kohima, and the impugned notification number such and such, dated 6/11/2024, issued by the Engineer-in-Chief NPWD Nagaland Kohima, terminating the work charge service of the petitioner. Stop. The case of the petitioner is that she was appointed as work charge Mali via an order dated 19/10/1994 on scale pay, isn't it? On
Yes,
scale
Your
pay. And thereafter, she had served the department for 30 years, for about 30 years. Stop. However, without any reasons before that you say, and she had in fact become eligible to be considered for regularization as per the various government office memorandums. Stop. However, without assigning any reason and without stating why she had been placed under the N category, N category, comma,
N subcategory.
N subcategory, comma, the state respondents have terminated her service. Stop. Issue notice returnable within 4 weeks.
Lordship, I have
Learned.
declared prior. If the show cause as well as notification may be stated.
No, not at this stage. It is already, you're already out. The impugned termination order is of 2024. Now we are in 25. Learned Government Advocate, AIME accepts notice on behalf of all the respondents.
Want to be responded on.
Respondents 1 to 8, hence no formal notice is called for. Stop. The Learned Counsel for the petitioner shall supply extra copies of the petition on the Learned Government Advocate during the course of the day. Stop. List after 4 weeks.
Oblige, Your Lordship.
For admission, item number 2.
May I please, my lord?
Yes.
Lordship, by the last order dated 13/6/2025,
Hmm.
Your Lordship, the respondent department was asked to prepare the latest LPC and submit it to the Accountant General Office, Your Lordship. The
Yes, I remember this.
yes, my lord.
What happened? Not
Yeah.
yet done.
No, we have already done. We have already submitted to the Accountant General Office on the dated 11th of July 2025. If I may be allowed to place this on record, my lord.
Okay. You have received a copy?
No, madam. Your Lordship, by while preparing this LPC, because the LPC has to be prepared effective from 2008. That is the year where the government employees expired, Your Lordship.
Yes.
And therefore, there was a necessity to get the approval of the Finance Department as well, Your Lordship. And therefore, we have taken the Finance Department approval also, and in this order, that is on the first page, Your Lordship. If you see the last para, the third para, Your Lordship, the finance concurrence has also been accorded, Your Lordship.
There and finance concurrence.
Yes, Your Lordship. And the next page is the last page certificate, Your Lordship, affecting on the 23/6/2008, Your Lordship. And
This is for the purpose of calculating the pension, isn't it?
correct.
So now this has been sent to AG.
Yes, Your Lordship.
Yes, Mr. Inti. Yeah.
Yeah, please, Lordship. My
Yes.
Lord, I'm appearing on behalf of my senior for AG. Lordship, the documents are still under process. If I waited 2 weeks, time maybe going to. We have already received the documents, however, the same is still under process.
Okay. Then sometime, Learned Senior Government Advocate, Mr. N. Nangami, has produced a copy of the LPC, the updated LPC, with effect from 23/6/2008. And he submits that the same has been forwarded to the Office of the Advocate General.
Accountant General.
Oh, sorry, Accountant General. Stop. Learned Counsel, such and such, MS such and such, appearing for the Accountant General, has submitted, yes, respondents, Accountant General / respondent number 5, okay? Appearing for the respondent number 5, Accountant General submits that the documents have been received and they are under process. And accordingly, she has prayed for how much time? 2 weeks time to process the same. Stop. Accordingly, list the matter after 2 weeks. Stop. Learned Counsel for the petitioner, MT Longchar, has no objections. Yes.
Months.
For admission, item number 3.
Please, Lordship.
Yes.
Your Lordship, the case of the petitioner is still under process. So Your Lordship, another 6 weeks will be granted. So on the next day, I can press the up-to-date status report.
Under consideration.
Yes,
What
Your
is under consideration?
Yes, Your Lordship.
Regularization.
Yes, Your Lordship.
Yes.
Lordship, that the government had filed updated status on the in the form of affidavit on next day.
You do that then?
Yes, Your Lordship. Also, 6 weeks will be granted, Your Lordship.
6 weeks.
Yes, sir, at least 6 weeks, because Your Lordship, the documents are in process. So, Your Lordship.
For status report.
Yes, for status reports, I will file on that day, on the next day, Your Lordship.
Learned Government Advocate Ms. Livika submits that the case of the petitioner is being processed and prays that she may be allowed 6 weeks' time to file the status report in the form of affidavit. So, Learned Counsel for the petitioner has no objection. At least after 6 weeks.
From the supplementary clause fees for admission, item number 17.
Here. But before this hearing now, I think this should be done first. No, yes.
Maybe, Mr. Lordship.
Yes.
My lord, the petitioner hearing is challenging the interim appointment order of the private respondent dated 28 June 2025, issued by the Director, Department of Agriculture. By which the private respondent number 5 was appointed as NTS under STAO Pongro. And on the ground that the case of the petitioner was not considered on land ownership, and also on the ground that it is against the office memorandum by which the children of the employee cannot be appointed after retirement, after taking
Yes,
voluntary retirement.
only one can be appointed
Yes.
according to the own.
So, with regard to the service on respondent number 5, this honorable court had already passed an order on 23/9/2024. If my lord may kindly come to the order 23/9/2024, or else I have that support.
23/9.
23/9. The second bit, since the office note dated 3/9/2024, the service of notice upon the respondent number 5 is still served.
Okay.
So the notice on the private respondent is still to be served. You know, the short facts of the present case is that altogether 10 landowners, the original landowners have submitted the land for the potato seed farm at Ponglo.
Okay.
Earlier, it was a potato seed, it was a farm only until it was until the office of STAO Ponglo was established in 2018. And it was under the administrative control. At that point of time, it was under the administrative control of Agriculture Field Assistant, AFA, Agriculture Field Assistant. And there is a written agreement. There is a written agreement of 1965. I'll come to the annexures. And without considering the case of the petitioners, in fact, none of the landowners have been appointed till date. Even after 58 years. Even after 58 years, the petitioners, on learning that there is a post of MDS vacant, applied for the same. However, in the communications of the department, it has been stated that he has submitted his applications after the last date of submissions. And the advertisement that was published was only in the official website of the department, which I have a citation. I'll be placing it. Allow me you to take
Your agreement is not dated. There is no date. Is it dated?
My lord, allow me to kindly take your lordship to the annexures, page 17.
Okay.
I'll just take your lordships directly to the annexures to save the time of this honorable court. Page 17. This is the type copy because the original copy is not readable.
It's not legible at all.
Page 17. Page 17. Page 17. Allow me to read it.
Yes.
Agreement of potato seed farmland acquisition Ponglo. In the undermentioned person, being the absolute owner of the land herein below, described in the schedule appended to this deed, today, the 27th October 1966, the date is mentioned, 27th October 1966, at 10 hours, in our own free will and without any coercion since equipped to the government of Nagaland, and taken our regards to the government. In return, under this scheme, Nagaland government may give first preference like contract works or others, etc. to the landowners if so fit by us, donors under bracket. The government of Nagaland will have absolute right to use the land in any manner as it deems fit, and we, our heirs and local representatives, will have no right whatsoever. Demarcations of the site, nor such and such, is such and such. The name of the landowners are below. The petitioner's grandfather is serial number 7. A lifetime impression of Nokoi, son of such and such. Serial number 7. And this was signed and agreed by agriculture inspector. So at that point of time, since this was a farm only, what a farm only, they were under AFA, agriculture field assistant. But their head, because this is under Bongro. So the Gifri, in Gifri, there was one agriculture inspector. So he has signed it. And on the right side, circle officer Bongro has also signed it. So this is the agreement of 1966. Thereafter, as I was mentioning, the SDO, Subdivisional Agriculture Officers Office was established in Bongro only in 2018. Only in 2018. And since the agreement of 1966 had become ineligible, the Subdivisional Agriculture Officer Bongro has typed out again the earlier agreement, that is 1966 agreement. Everything was same. He has not added anything more. The agreement was as it is. However, he just added some detailed information with regard to that. Allow me to take your lordship to page number 21. 21 of my petition.
Yes.
So this is the detailed information that he has inserted. East such and such feeds, north such and such and such. The landowner witness remains the same. The last column of this page number 21, a copy of the date of agriculture where acquired the land, not applicable. Then the next page number 22, name of the employees appointed against the landowner. No employees appointed against the landowner. And remarks, Potato Farm Bongro was established in 1965 with an objective of conducting crop demonstration and seed production. The farm implemented multitude of successful demonstration on various groups. Meanwhile, altogether 21 numbers of farm managers were designated so far to look after the functioning of the farm. So this is the little detail that the SDO has added in the year 2021. This is signed on 27/7/2021, which can be seen in page number 19 of my petition. 27/7/2021.
Okay. 27.
The agreement remained the same, just that it was ineligible, so he has retracted it without just by adding some more details on how the land was acquired. So thereafter, on learning that the petitioner on learning that there was a vacant post of multitasking staff, applied for the post, which application can be sent in page number 23 of the petition. This was supported by a no objection certificate from the village council chairman. Allow me to read it. No objection certificate. This is to certify that Mr. Ningsuk Chumar, son of such and such, was the great grandson of late such and such of Bongro village, is an actual landowner of Potato Seed Farm under Subdivisional Agriculture Office, Bongro, which is situated at half kilometer away from Bongro Town headquarters, was donated by such and such on 27 October 1966. Therefore, the Bongro Village Council serves this no objection certificate in favor of Mr. Such and such, that is the petitioner, to claim for grade 4 post in Potato Farm against the landowner Kotak. Now, thereafter, my application was forwarded by the SDO, dated 6 March 2024. Forwarded to the director, and I was informed that there was an advertisement. While submitting the thing, I was informed that there was an advertisement, status of 26 February 2024. This advertisement was for different posts And
MTS is also there.
MTS,
STO Pungro,
yes.
9.
So this is the advertisement. So this advertisement is of 26th February 2024, giving 8 this time only. Number one, it was published. This advertisement was not published in any newspaper. It was published only in the official website. Number one, only in their department official website, and giving only 8 days time to submit the document. I'll come to that again. Thereafter, committee was formed on 13 March 2024. That is page number 27. Departmental Screening Committee was formed, white order dated 13 March 2024, page 27. And the committee has submitted their meeting minutes. Allow me to take your lordship to page number 32. This is the meeting minutes that they have submitted to the government. The Departmental Screening Committee has submitted to page number 32. Is my lordship there? Page number 32. From the last column, the fifth and sixth one. From the last 1, 2, 3, 4, 5, 6. Serial number 1, Sri Thong. Yes. Group qualification is this one. And on the remark column, Chinese applicant, but as Chinese applicant, yes. And number 2, Sri Nongsubyul Mchungar, which is the petitioner, Metro Research in fact.
Applicant, what is
Here in the remarks column, Chinese applicant, but his application was received after 5th March 2024, which was the last date of submission of application. So my application was duly forwarded, yes, no doubt. But in the application, the Departmental Screening Committee has failed to mention that I have applied on land ownership basis. And that this is how my case has not been considered by the government.
And this Thong Neo is the private respondent?
Yes, yes. And since the Departmental Screening Committee has failed to mention that I have applied the post on land ownership basis, the government did not consider the government had no opportunity to consider my case on land ownership. In fact, it is the department who has made the mistake, Departmental Screening Committee. Thereafter, administrative approval was given. That is at page number 33. And then the immediate appointment order is at page number 35.
What does the government say? What is the government
The
stand?
government, in the government affidavit, they are saying that the agreement was not made at the level of the government, number one. And they are saying that we have followed due process of law in appointing the private respondent number 5. That is all that they are saying.
Miss, who's appearing for government? Anybody appointed on basis of land ownership in this place?
No problem.
Your lordship,
Yes.
on that, I don't have any instructions, but whether any appointment, landowner was appointed.
Because if no landowner has been appointed in that particular place, then in view of the memorandum of 5th March 2018, at least some verification has to be done by the department.
The sole basis on claiming the land ownership appointment is based on the agreement. So,
Yes.
your lordship, I would like your lordship to take to the agreement, your lordship.
Yes, that annexure, no, page 17.
Yes, your lordship.
Hmm.
Though the petition or the petitioner's counsel I already read, I would also like to read your lordship. In the undermentioned persons being the absolute owner of the land herein below described in the schedule appended to this deed
today, the 27th October 1966 at 10 hours in our own free will and without any coercion, since bequeathed to the government of Nagaland, in taken our regards to the government. In return, under this scheme, Nagaland government may give first preference like contract works or other etc. to the landowners if so fit by us, donors. The government of Nagaland will have absolute right to use this land in any manner as it deems fit, and we, our heirs and local representatives, will have no right whatsoever. Your Lordship, this land was donated free of cost, Your Lordship, and there is no condition for providing appointment, Your Lordship. In the agreement, there is no condition, Your Lordship, for giving appointment. So the petitioner does not have a right to claim for appointment based on this agreement, Your Lordship. There's no condition at all, Your Lordship. And
Yes, only regarding contract works.
yes, Your Lordship.
Allow me to.
And I would also take Your Lordship to page 38 of the petition, Your Lordship.
Yeah, the policy.
Yes, the policy. The clause 2, Your Lordship, of this policy law. All cases where administrative headquarters or block headquarters were set up in various parts of the state on lands donated freely by individuals, villages, or people of that area should not be reopened for compensation or for employment in consonance with the policy brought out by MO's memorandum such and such. Your Lordship, the policy is also for Your Lordship, it's very clear, Your Lordship. One, in the agreement, there is no condition for providing employment on land ownership basis. And the government policy is also clear, Your Lordship. When there is no agreement, Your Lordship, we cannot claim appointment on the basis of land ownership.
You come to 3A also. 3A also, it says, in other cases prior to 26/7/25, where a specific written agreement exists. So there has to be a specific written
Yes, Your Lordship,
agreement
there's no
to
specific-
provide employment. But here there is no such.
Your Lordship, allow me to submit on this.
Yes.
First of all, this deed of agreement was made on 27 October 1966. 1966. Allow me to rely on that. In 1966, we Nakas, we were still, our eyes were not open. In fact, our eyes were not fully open. It was drafted at that point of time. Number 2, contract work or other etc. In a government setup, what etc. may be made? Contract work, yes, there may be, but till today, 59 years, none of the landowner has been awarded any contract work. Number 2, what do we expect from a government setup? It is a grade 4 post only. So etc. will cover in other etc. contract work, other etc. This will cover my case. And this was drafted in 1966, as I'm submitting it. 1966.
Anything
We
else?
have to go by as per the policy, and Your Lordship, as per the agreement is concerned, Your Lordship. This is also not a legal document, Your Lordship, because this has not been signed by the authorized state government, Your Lordship. And in that regard, Lordship, I would like to rules of executive business, Your Lordship. So I've also made a specific statement in my affidavit, Your Lordship. I also like to check Your Lordship to this.
Yes.
Rule 11, Your Lordship. Rule 11, told of like, Your Lordship. In order for it to be a legal document, Your Lordship, as Your Lordship knows, Your Lordship, or an instrument of the government.
This was signed by circle officer.
Yes, Your Lordship.
Circle
It has
officer.
to be either from the chief secretary level till under secretary, Your Lordship. So this also is not a legal document, Your Lordship. So the whole basis on which the petitioner is seeking land ownership appointment is illegal, Your Lordship. They don't have a claim, they don't have a legal right to claim for appointment, Your Lordship.
This notification.
No right will flow from those landowners who have donated freely, free of cost, Your Lordship, and now they're claiming that appointment on the basis of land ownership, Your Lordship.
This notification is of 10 July 2020. Will have retrospective effect.
We'll see, we'll dispose it of, dispose.
In that-
Chamber dispose of, okay? Chamber dispose.
Allow me to make a small submission.
Yes, yes. No, we've
If-
seen everything, yes.
If the case of the petitioner cannot be considered on land ownership,
Mm,
in that case,
mm,
I have a small bit.
Mm.
A small observation will be made by this honorable court
mm.
that
For,
the petitioners or the landowners
Mm.
will have every right to claim compensation for the land that they have already donated. Because the agreement is of 1966,
Mm.
59 years has elapsed.
Mm.
No compensation, no nothing. Contract work not allotted, not awarded. So petitioners will have every right to approach the authority for compensation for the land already used
Mm.
for the past 60 years
Mm.
and to require the land.
But
will be
there's
the-
already
that
a
will-
policy, Your Lordship. We can't
if-
go against the policy.
If that will be,
I also like to try.
Mm.
It's just-
this is also regarding landowner.
Yes.
ownership. Mm. What were the facts in this case?
Here also the claim on the, was on the basis of the one agreement.
Mm.
So that agreement was found to be illegal, Your Lordship, because there was no, this thing was not as per the rules, Your Lordship. The agreement was not
Okay.
executed as per the rules.
with regard to the advertisement, I have also one suggestion, 2011, voluntary SSC. I have submitted.
Okay, we'll just keep it here. Xerox, make a Xerox copy and.
Much of it.
Yes. Disposed, okay.
For admission, item number 18.
Mm.
Initially appointed between 1989
Mm.
and the dates, there are the issue and the expert is relevant. So March to be issued by the.
Mm.
Lordship,
Work charge.
yes, Lordship. Also, in compliance with this office memorandum, executive engineer, medical engineering division submitted the list of overclass employees.
Mm.
Uh,
How many years you've been serving? For how many years? 30 years, then?
Yes, Your Lordship.
Ah.
So, I'm considering that like, the petitioner, they fall under this memorandum. Your
OM,
Lordship.
huh?
Yes, this OM, Your Lordship, and as per this OM, close stream, Your Lordship, we have processed, and now it's before the cabinet, Your Lordship. Everything has been processed. I have also filed the status report, on 5th June, that everything has been done and it's before the cabinet for approval, Your Lordship. 5th June, Your Lordship,
5th June.
of my affidavit, Your Lordship. Filed by the government.
Mm. Okay, affidavit on behalf of 1, 2, 3, and 4.
Yes, Your Lordship. So, Your Lordship, we have processed and now it's before the cabinet, Your Lordship. So,
Okay, so how much time will it take then?
so Your Lordship, at least a minimum of 3 months may be given to us so that.
3
like-
months.
Yes.
We
so
can-
that
let's
like-
dispose it of that,
Yes. Your
giving
Lordship.
you 3 months
That
time.
line here.
Mm.
That-
Yes.
the hearing here.
Mm.
The petitioner's case is also covered in the office memorandum in the 2nd September 2004. In my additional affidavit, I found that the petitioner's case is covered under this office memorandum also. Okay. Procedure is page 7.
No, but main thing is the OM dated 17/3/2015 is. Okay, this petition has been filed by the petitioners bring for regularization of their work charge service on completion of 30 years. Stop. I have heard learned counsel for the petitioner, MS such and such, and learned government advocate, Ms. Livika, for the state respondents. Stop. Next para. The petitioners were appointed as work charge employees in the office of the executive engineer, medical engineering division, Kohima, Nagaland, under the establishment of the Department of Health and Family Welfare, Nagaland, Kohima, by office orders dated 20/12/89, 1/10/88, 27/6/90, nil January 1990, nil January 1990 for petitioner number 4 and 5, and 5/12/1990, and presently drawing scale of pay. Stop. It is stated that the petitioners have been serving the department for more than 30 years without any break in service, and are therefore eligible to be considered for regularization under the office memorandum number AR-3/GAN-67/2001 PT under bracket dated 22/9/2004, and office memorandum number AR-3/GEN-2001/2009 dated 17/3/2015. Stop. The state respondents have filed an affidavit on 5/6/2025 stating that the petitioners were found eligible for regularization of their service as per the OM dated 17/3/2015, and the cases of the petitioners were therefore processed for regularization. Stop. It is stated that the clearance for creation of 8 posts was obtained from the PNAR department Vite U.O number 868 dated 20/12/2021. Stop. Thereafter, the concurrence of the finance department was also obtained Vite RFC/ESTT number 35/25 dated 19/2/2022. Stop. The recommendation of the Manpower Rationalization Committee was also obtained Vite number AR-GEN-331/16 volume -2 Roman 2 in brackets dated 18/10/2024. It is stated in the affidavit that the case of the petitioners have been submitted to the cabinet cell on 26/11/2024 for approval. Stop. Learned government advocate therefore submits that the cases of the petitioners are already under consideration as stated herein above. Stop. Para. In view of the fact that the petitioners are eligible for regularization under the aforementioned office memorandums dated 17/3/2015, and in view of the fact that the respondents have already processed the cases of the petitioners for regularization of their work charge service, the petition is disposed of with the direction to the government respondents number 1, 2, 3, and 4 to complete the process of regularization within a period of 3 months
From the date of.
from the date of receipt of this order. With the aforesaid directions, this petition stands disposed.
Chocolate.
From the supplementary course list one for admission, item number 19.
Can it be referred? If it is on quantum, no, we'll refer everything. Is it quantum or legal point is involved? No, even if it's not settled, it's okay. It can always come back. No, award is challenged on quantum or other points, other ground,
Other grounds are okay.
other grounds. Then that means it cannot be settled. Learned counsels for the parties are present and have submitted that the petition involves legal points which need to be adjudicated by the court and therefore cannot be referred for mediation. So accordingly, list the matter in usual course for admission.
Actually, this was listed day before yesterday, and 3 weeks time was so. In 2 weeks time was for yes.
So we'll just say
After 2 weeks.
list after 2 weeks then. Or as indicated in the previous orders. List the matter as indicated in the previous order.
Your Lordship,
Yes.
if you allow, I would like to also mention other cases, other items as we have seen the submission and also we are the same also.
Those which cannot be sent
Yes.
for mediation.
Yes.
Okay, which are the items?
Item number 19, 22,
22,
29,
29,
30,
29, 30,
33,
33,
34, 36, 37,
34, 36, 37,
38, 39.
38, 39. So same order, just say that the councils have submitted that it involves legal points which cannot be settled in by way of mediation and needs to be adjudicated by the court. Na? And accordingly list the matter as indicated in the last court order.
Your Lordship also.
Yes,
Item number 45.
45 also.
Yeah.
Okay,
Here I
45.
am the respondent,
Okay.
opinion
Okay.
for enhancement of compensation.
No, if it's for enhancement, then it can be sent. Item 45.
Yes.
Okay, don't put item 45. Okay,
Much obliged.
yes.
For admission, item number 20.
What about this?
Worship, I'm applying for the applicant to teacher too.
Hmm.
I was instructed to submit that this is for enhancement. So
So
no
enhancement,
scope for mediation.
no, if it's enhancement, it can always be mediated. If they agree to the enhancement.
This has the instruction by way for respondency.
Hmm. Okay, okay. This one also, the learned counsels for the parties submit that the matter needs to be adjudicated by the court. And therefore, list the matter as indicated in the previous order.
For admission, item numbers 21 and 22.
22 already mentioned.
May I please, my lady? My lady, item number 21, 22, admission 35.
Hmm.
I do not have the instruction from my corporation to get it mediated. And in that eventuality, my lady, I beg to pray before this honorable court that these cases may be disposed on merit because legal points are also involved in this.
Legal points are involved.
Yes. Item number 21, 22, 35.
21, 22, 35 also cannot be sent for mediation as legal points are involved which need to be adjudicated by the court. Na? So list the matter as directed in the last court's order.
And my lady, hearing
referred.
item number 40.
Has it been referred?
Not referred, not referring. These are not referred. 21,
Okay, but-
22, 35
Okay,
not
but
referred.
just make a refer to one
Yes.
item that is 27.
Uh,
This is also listed, but
uh,
today,
mm.
I want to try in this spot. It cannot be.
It cannot be mediated.
Not sure it cannot. Because my party is in that, will not be agreeable to that. But still, because and to Dr. Lordship, we have a very good ground.
Acha, acha. That's why legal points need to be.
Yes.
Okay, so 27 also. 27 na? 27 also mentioned it cannot be sent, so same.
Lordship,
Mm.
that these cases were supposed to come up on Monday.
No, it will come up as and when directed by the court in the last order.
Yes. Right.
Yes.
For admission, item numbers 23 and 24.
No one wants to send for mediation. What about 23, 24?
Maybe so.
Yes, this one can
My-
can we refer?
My lady, there is enough here.
Oh. Wait, anyway, let me see the prayer portion.
In fact, the claimants, they've been given 50% of their work. Maybe they're feeling they're ready to.
No, no, on what ground they have challenged? Acha, acha. Okay, okay. So that also we cannot, this also cannot be referred, so listed as and when directed by the court in the lawsuit. Yes.
For admission, item number 25.
Your Honor, this is a compassionate appointment case.
Compassionate appointment, this one also, but petitioner is not there, na?
Yes, he informed me he was indisposed. So,
Hmm.
yes.
Can we refer it for mediation? Because if you are not disputing that he is entitled,
I'm yet to receive any instruction on this, so. Can't say much for that.
no, you appear before the mediator and you take some time.
Much.
No, you can take some time for instructions. Okay,
Much.
yeah. Learned government advocate, M. Longcomber is present. Learned counsel for the petitioners, but you have taken the consent, no, from the petitioner?
Yes, but not with regards to the referent.
Uh, Anyway, you tell the petitioner also to appear, no? None appears for the petitioner. So, however, having found that there are ingredients for settlement in the present case, the matter is referred for mediation under the special mediation drive. So, the parties shall appear before the registrar of the Gauhati High Court, Kohima bench. On what date? I'll give a date. On any day. Tomorrow. Tomorrow?
Is indisposed, so I don't think.
Or then next week on 28, on 28 July 2025. Stop. List the matter as and when the mediation process is completed, along with the report of the mediation proceedings. Stop. Yes. You appear before the registrar and they will give the instructions. Okay.
For admission, item number 26.
This is also a compassionate appointment.
You try mediation? Yes.
Service of time, army service.
No, that's why.
Proceed to normal course.
No, if they are not disputing that you are entitled, then it can be settled. Have you filed counter? Not yet, not yet. Yes. Normal course. Because during the mediation, if they say that they are willing to give you appointment, then that serves your purpose. Oh, okay, okay, fine. Learned counsel for the petitioner submits that the matter needs to be adjudicated by the court and therefore cannot be sent for mediation. So accordingly, list the matter as directed in the last court's order.
That's done.
For orders, item number 30.
30 already mentioned, I think. No, 30 already mentioned.
For orders, item number 31.
Anyone? Petitioner? No. Learned PP is present for the state respondents. None appears for the petitioner. However, the present case has been identified for mediation under the special mediation drive. So accordingly, the matter is referred for mediation. So the parties are directed to appear before the registrar of the Gauhati High Court Kohima bench on 26, or let it be on the same day, 25. No, what did I say? Last 27. Oh, 20, sorry. 28th of July, 2025, for mediation. Stop. List the matter after the mediation process is completed, along with the report of the mediation proceedings. You tell the petitioner also, okay?
For hearing, item numbers 40 and 41.
32 is also mentioned, 32, 35 mentioned. Oh, This, okay. This one also, what is this about?
The matter pertains to this damages.
Pending bills, pending bills. Counter filed.
Existed, the scheme was not extended by the Union of India. And we have written to the state government that since we have dropped the scheme, if you want, you can continue. If you don't want, you can continue yourself with your own expenditures. Even after that communication, they have given a work order to the petitioner. So who will pay it? We have said we will not pay. But instead of that, they have continued.
Before the work order was issued, you have
Yes,
stated.
yes. So they other that even if there are communication that we will not support, we will not continue with the work. They have continued to work, and now we are not able to pay now. So let the step one, the step pay. That is the only question.
Sure.
We are not eligible. We are not.
And what is the state saying
The state has
in their
not-
counter? Not filed.
Habibur on behalf of his marriage,
Mm.
engaged before court of worship.
In that case, can it be referred mediation?
Lordship, they have filed an affidavit in opposition.
Mm.
They objected to us.
They're disputing.
Yes, Lordship.
Okay, in that case, it cannot be sent then. The counsels for the petitioners and the respondents are present. It is submitted that the matter cannot be referred for mediation as there are disputed questions involved. So accordingly, list the matter as directed by the court in the last order.
For hearing item numbers 42 and 43.
Mr. Worship. Your Worship, in this case, on the last occasion, the counsel for the petitioner have withdrawn her name. So I will be appealing for the petitioner and filing my bakalat nama only today. In this
Oh.
case,
What is the matter about? Why is it
it's
identified?
for compensation.
Compensation.
They have already filed their affidavit in opposition, so there is dispute in the.
There is dispute. Learned counsel, such and such, appears for the petitioner, isn't it? First time appears for the petitioner. And have you filed your vakla nama?
We have filed only this morning. Your
Okay.
Worship.
Appears for the petitioner and submits that she has filed her vakalat nama for the petitioner only this morning. Stop. Learned counsel for the state respondents present. The counsels for the parties have submitted that since there are disputed questions of facts in the present petition, the same cannot be referred for mediation. Stop. Accordingly, this is the matter as directed in the earlier court order.
For hearing item number 44.
Disconnected.
Yes, what about this?
This matters with regard to compassionate appointment. And I'm also aggrieved by the manner in which the respondents have adopted in appointing compassionate appointments, making compassionate appointments. However,
So it cannot be settled. If they are agreeable to giving you an appointment,
looking at the situation, since it is for compassionate appointment, I would like to try for
mediation.
mediation. If it fails, then we can.
If it fails, you can always come back. Learned counsel for the petitioner, Mr. Tushi Longkumar and Ms. Such and Such, learned government advocate are present. Stop. Since the court finds that there are ingredients of settlement in the present petition, the same is referred for mediation under the special mediation drive. So the parties shall appear before the registrar, Gauhati High Court, Kohima bench on 28 July for the mediation process. Stop. List the matter after the mediation process along with a copy of the mediation report.
For hearing item number 46.
May I please, my lady,
Yes.
here, the parties would like to continue the petition.
With the litigation.
The matter has all been settled. And the petitions that I had before this honorable court disputing the facts.
Okay.
So
Learned counsel for the petitioner.
I'm for the respondent.
For the respondent, Mr. Fuseko submitted that there are disputed questions of facts involved in the present matter and it needs to be adjudicated by the court and therefore it cannot be referred for mediation. Stop. Accordingly, list the matter according to the last court order. No, list the matter as directed in the last court order.
Pleasure.
For hearing item number 10.
The mediation one is over now. Yes, Mr. Levin,
Uh,
what's the matter of it?
My lord, I'm aggrieved by the imperial order. Imperial order dated 17 January 2023, page 38.
Page
38.
28. Yes.
There's an imperial order.
Hmm. Please read.
What
happened?
In pursuance to the government approval, white letter number so and so dated 17 January 2023, Srimati Piamola Pom Iso is hereby appointed as multitasking staff in the District Horticulture Office, Kohima, under Horticulture Department in pay level 1 of the pay matrix, plus all other allowances as are admissible under the rules and forth from time to time with effect from the date of taking charge. So I'm aggrieved by this imperial order. My lord, coming to my application, my annexure A, this is page 15. Page 15. I've been appointed on 11th April 2000.
Sweeper.
Yes, as sweeper. Then,
On work charge.
yeah, on work charge. My lord, here, I want to come back to page 48. Page 48, annexure K.
Hmm.
So as per page 48, extension order
Which?
48.
Yes.
Yeah. Extension order.
Hmm.
My name is reflected in serial number 2, Azono Belho.
Yes.
The order stated that in presence of the administrative approval letter number so and so dated 16 May 2023 in the interest of public service, the following full-time casual employee under District Horticulture Office is hereby extended for a period of 1 year with effect from 1st April 2023 to 31st March 2024. So my extension has been made. Now, in view of the government order OM, that is page 49. Page 49. Page 49, clause 3 and 4. 3 and 4. Under 3 and 4, my lord, I would like to come to a clear page. Affidavit in opposition, my lord, please.
But you have put a typed copy also. Typed copy is there.
No, I couldn't make a type copy, so I'm referring to the same affidavit in opposition of the state respondent.
Isn't this your typed copy, page 50, in your writ petition?
My lord, yes. Yeah. So I read up number 3. 50% of the regular vacancies of similar nature arising in a year will be reserved for regularization of work charge employees. And the remaining 50 will be filled up per normal rules of recruitment. Number 4, work charge employees have a right to be considered first for regularization against 50% of all future vacancies of similar nature in the department for which they possess the requisite qualification. Such regularization will be considered on the basis of seniority cum merit. So here I'm claiming seniority cum merit. This means that the senior most work charge employee in the relevant category will be regularized subject to his or her fitness for the vacant post. So I've applied for the same and I have applied in view of the release order, that is page 18. My not like copy is page 19. Yeah. In the interest of public service and with reference to the government of Nagaland Administrative Reform Branch, letter number so dated 7 August 2010, section 3(1) and section 3(2) of Nagaland Retirement from Public Employee, Second Amendment Act 2009. The following staff under the Department of Horticulture are hereby released on completion of 35 years of service retirement. Detailed particulars are mentioned in Annexure A. My lord, Annexure A is in page 21. So, page 21.
Yes, the
So
list of persons.
Yes, so I
Retiring.
make application in respect of serial number 2. Gave Yosto Chishi. Multitasking service as staff, THO Kohima. Serial number 2. Birth of date 15/3/1986. Joining of service December, not very clear, but the superannuation is 31/3/2023. Against that, I have made my application. Now, my lord, coming to page 23. Page 23. This is the forwarding letter of the additional director on dated 27 September 2022. My lord, my serial is on page 24. Page 24, serial number 6. Serial number
Teacher,
6.
I remember this case.
Yes.
I think the government was directed to
Yes,
file an
the government was
affidavit.
directed,
Isn't it?
yes,
It's filed.
Yes,
Fine.
Your Lordship.
yes. Now, here in this, my application is for regularization. Yes. Now, my lord, coming to the same affidavit in opposition of the respondent 1, 2, and 3. That's page 16.
Then the government reply was that the 8 vacant posts was filled up by way of seniority.
For in-service
For
employees.
in-service, and the other respondent number 4 was appointed against the
Fresh recruit.
9 posts which fell
Yeah.
for the quota for
Yes.
direct recruitment.
Yes.
My lord, my
So-
point is on this.
So the
in this
seniority,
page.
so the court wanted to know about the seniority position.
Yes. Now, my lord, coming to page 17. 17 is very clear. Page 17.
Page 17 of,
Page 17 of the affidavit in opposition.
yes.
The second para.
Hmm.
Regularization of in-service. I
Yes.
read out.
Yes.
Regularization of in-service casual employment employees to be strictly on the basis of the OM dated 22/4/2004. Hence, the ratio of the existing vacant
Sanction
sanction
post.
post shall stand at 8
8:9.
8:9 for regularization and fresh appointment. Regularization to be done strictly
On the basis of.
on the basis of seniority district wise.
So 8 posts for regularization,
That is
9
what-
for
Yes,
New
that is what they have
appointment.
the The government has brought out this,
Yes.
but see seniority wise. So it is strictly on district wise. Now I'm from the district of Kohima. Now, my lord, coming to annexure A,
Annexure A,
I mean, page 18.
page 18.
Yes. So page 18, here, serial number 1 is from Futuro. Number 2 from Futuro. Number 3 is not indicated. 4 not indicated. 5 is from Loknak. 6 is Dunaboto. 7 Mokokchung. 8 Tuingsang. Now, my lord, coming to the additional affidavit of the state, additional affidavit of the state. This honorable court has passed an order dated 8/5/2025. That is this thing, additional affidavit. So this honorable court has passed these orders. The state respondent are given 3 weeks time to produce a copy of the government seniority list showing the seniority of the petitioner vis-a-vis the seniority of the 8 employee who were recommended for regularization by the special committee by circular dated.
Okay, we'll just take a break.
3.
Come back after 5 minutes. Okay? Yes.
Your Honor, page 6, additional affidavit.
Petition affidavit, yes.
Yes,
Yes.
I read out from the second paragraph. The said respondent are given 3 weeks' time to produce a copy of the government seniority list showing the seniority of the petitioner vis-a-vis seniority of the 8 employees who were recommended for regularization by the special committee constituted by circular dated so and so. The state respondent shall file the same by way of affidavit. So, my lord, in Annex P, this is page 7. My name is here reflected in serial number 8. As the senior most under DHO Kohima. DHO Kohima. Now, my lord, coming back to the affidavit in opposition. Affidavit in opposition, page 16.
Page 16.
Page 16. Page 16, second. Page 16.
The vacancy which arose was in Kohima.
Yes,
Yes, page 16.
yes, page 16. I read up from the second para. Attendance is annexed. From there,
Yes.
initiating the discussion, the joint director and head of department informed the members that at present there are 17 grade 4 vacant posts under various establishments against which the department is in the receipt of 69 applicants. My lord, I would like to take
69 applications.
yes,
From in-service.
69
and
applicants.
As well as fresh appointment.
Yes. For regularization, fresh appointment and appointment on compassionate ground. At present, there are 147 fixed employee, casual employee, grade 4. Many of these employees are serving for more than 20 years. So, my lord, coming to page 7 of the same. This is the forwarding letter. This is resubmission. Page 7 of the affidavit in opposition, page 7. So the subject states resubmission. So under this resubmission, there are 69 applicants. 69 applicants. Wherein out of this 69 applicants, and in view of the meeting minutes, page 17. Page 17, it is very clear. Regularization to be done strictly on the basis of seniority district-wise. So that's page 17. Second para. Page 17.
See,
Yeah,
now
of
you cannot
affidavit in
claim regularization against a post which is proposed for direct recruitment. You can only claim against the post which is for regularization.
Exactly, that was my application. That was my application before
But private respondent was appointed against the direct appointment quota, isn't it?
Yes.
Yes.
So you cannot challenge the appointment
Now,
of the.
my lord,
Yes.
see, let me give my submission. My lord, in page 17 of the affidavit in opposition, the second para, regularization, I read out again. regularization of service casual employee to be strictly on the basis of OM dated 22/9/2004. Hence, the ratio of the existing vacant sanction post shall stand at 8:9 for regularization and fresh appointment. Regularization to be done strictly on the basis of seniority, district-wise. So, in the additional affidavit, I am the most senior from the district. The minute says it will be done strictly on seniority district-wise. The minutes dated 10 January 23. It states strictly on the basis of seniority district-wise. So, in the
The others who have been regularized are all senior to you, except this serial number 9. The one who is at serial
Yes.
number 9 is here at 5.
yeah.
So how?
Now, Your Honor,
Yes.
if you come to page 18 of the affidavit in opposition, page 18,
Yes.
vacancies created. So, 1 to 8, they are recommended for regularization. So, what I'm saying is that in serial number Sri Kafo, so and so, Kafo is MTS senior number 1 from HRF Futuro. HRF Futuro. Then serial number 2, seniority number 2 under HRF Futuro.
Okay.
Then
Okay.
number 3 is seniority number 1 from SHN. Then number 4 is seniority number 2 from SHN. So number 5 is Loknak. Number 6 is Zunupoto. Number 7 is Mokok Chun. Number 8 is Tuing Sang. Now, if we come back to page 17, the minute says regularization to be done strictly on the basis of seniority district-wise.
District-wise.
That's all. So, in the additional affidavit, my name, I'm the senior number 1 in the district of Kohima. So, according to the Annexure A, now the selection process has not been done under the minutes of under the minutes dated 17 January 2023. So by virtue of the minutes and by virtue of the seniority list, I should be appointed. That's all.
Your Lordship,
Yes.
17 vacancy arose,
Ah.
and the special committee that was constituted decided that 8:9 ratio should be followed. So 8 posts were given for in-service, 9 for fresh recruits. Now, petitioner here is challenging the appointment of respondent number 4, who was appointed as fresh recruit. That is from a different quota. So he has no local standby to challenge the appointment of respondent number 4, Your Lordship. If he wants to challenge, and he can challenge those who were appointed from in-service regularization among the 8.
But in service, those others are all from other districts.
Yes, Your Lordship.
They're all from other districts appointed against posts which arose in their own districts. But as far as Kohima is concerned, that post which was vacated was identified for direct
Fresh recruits.
recruitment.
Yes,
That
Your
is the
Lordship.
problem.
Yes, Your Lordship.
Mm. But now, as of now, the petitioner is at serial number 1
Yes, Your
in
Lordship.
Kohima.
Yes, Your Lordship. Your Lordship, just off records, I was always off records, Your Lordship. I was informed that vacancy arose presently in Kohima, and petitioner has submitted his application also.
See, Mr. Ilivil, the government policy was 8:9 among the to divide the vacant posts.
My
So
lord.
8 posts identified for regularization, 9 posts identified for direct recruitment. It so happened that the post for Kohima was identified under the direct quota, direct recruitment quota. So how can you claim against that unless there's another vacancy?
My lord,
At best, this court can give a direction to consider in the next vacancy.
my lord,
Mm.
if we go to page 18 of the affidavit in opposition,
Page
Page
19,
18,
18.
1-8,
No. Yes.
1-8 and referred to 17. So 1-8,
Mm.
serial number 1 is Sri Nit Solo Kafo MTS Unity number 1 under HRF Federal.
Mm.
So number 1 is seniority number 1 at Federal.
Mm.
Number 2, Sri Kedulhi Tele, seniority number 2 under Federal.
Mm.
Yes. Then number 3, G Inasia Sema, seniority number 1, SHN. Then number 4, Siri Vilal Hudolo, seniority number 2 under SHN. Now, coming to the minutes. The minutes is very clear that regularization to be done strictly on the basis of seniority district-wise. Now here in this annexure B, I mean annexure A. So this cell number 1, 2, 3, and 4, they are from one particular district. So the question of regularization to be done strictly on the basis of seniority district-wise. That is the question. So district-wise it should be given. Now here in annexure A, 2 are given in one district, another 2 are given in another district. And if we are supposed to take into the resubmission of application, that is 3rd January 2023. 3rd January 2023. My lord, the applicant name.
No, but how can this court?
Whose name are made in annexure A, serial number 1, 2. They are not, their name has not been submitted. Their name has not been submitted by the Joint Director. 3rd January 2023. Resubmission of application received for regularization. The name of those people who are mentioned here in serial number 1, 2, their name are not, their name has not been forwarded. Now the case has been considered. Annex, yeah. Page 7 to page 14. The name of these 2 persons, Nitsulho Kafo and Kedulhi Tele, their names are not forwarded from the department, yet they have been regularized. My case, I have made my application.
You mean the forwarding of applications in your annexure D, page
No.
23.
My lord, in
In
this
that, their names are not there, you mean?
affidavit in opposition of the state, respondent 1 to 3.
No.
That is page 7.
Acha, acha. In this, their names are not there.
Yes. in the-
Pre-submission.
Yes, in the application forwarded,
Hmm.
the names of this who are appointed in annexure A, 1 and 2, their names are not reflected in the application that has been forwarded.
Hmm. But they are not before this court.
Of course, they are not
They're
before this
before
court,
this
but
court. And the court cannot do anything unless they
my
are,
lord,
unless
see,
they are impleted.
yeah,
We
but my
can
lord,
confine to the ones who are before the court.
but my lord, see,
And
here,
court cannot give a direction that this post should be under direct recruitment and this post should be for regularization. That is up to the government to decide which ones to choose, which post to choose for direct recruitment and which post to choose for regularization. The court cannot direct. At best, we'll dispose it of with the direction to consider your case in the next vacancy. Okay. Otherwise, here the court cannot interfere much.
that is up to the
Mm.
court.
Because they're saying that vacancy has arisen in Kohima district, isn't it? Can I put that on record? Saying that a vacancy has arisen?
No, no, your lordship, that's off record.
See,
This writ petition has been filed by the present petitioner, praying for a direction to appoint the petitioner to the post of sweeper grade 4 at the District Horticulture Office, Kohima, on the strength of being the senior most work charge, isn't it?
My
You
lord.
are now the senior most work charge employee in the district of Kohima. And also praise for direction that the notification number HR/DTE/ESTT-29/N.G ministerial under bracket 2022/1093-1109 dated 17/1/2023 to be quashed and set aside. Yes, stop. Next paragraph. I have heard learned counsel for the petitioner, Mr. Elivil Zhao, learned government advocate, Ms. A. Ayemi, and Mr. Tongpok Pongoner for the respondent number 4. Stop. Para. The case of the petitioner is that she was appointed as works charge sweeper via an order dated 11th April 2000 and has been serving as such for the last 21 years. And now she is the senior most works charge employee in the office of the District Horticulture Officer, Kohima. Stop. The petitioner, having learned that one Shri K. Vitoi Chishi, Vitoi, had retired from service, made an application for appointment against the said vacancy. In terms of the in terms of the office memorandum, where was that? Office memorandum number AR-3/GAN/67/2001 BT in brackets dated 22nd September 2004, which is a policy formulated by the government of Nagaland for regularization of service of work charged employees. Stop. Para. The petitioner states that the additional director of horticulture forwarded to the government/respondent number 2 a list of the applications for regularization/appointment/compassionate appointment from this starting from serial number 1 to 61, wherein the petitioner's name figures at serial number 6 of the forwarding letter dated 27th September 2022. Stop. That in that list, there were 5 applicants applying for the post vacated by one Shri K. Vitoy Chishi, and the petitioner was the only one seeking regularization under Kohima district. Okay, Vitoy Chishi also retired from this office of district. It is also mentioned that Shri K. Vitoy Chishi retired from the office of the district horticulture officer Kohima. Stop. It is submitted that the name of the respondent number 4 was not forwarded. Yes. Oh, it's time. No. It's not yet time. I thought this clock was going slow. Anyway, it is submitted that the name of the present respondent number 4 was not included in this list. Stop. Thereafter, another list of applicants was resubmitted to the respondent number 2 by a letter dated 3rd January 2023 by the respondent number 3 / joint director and HOD. Stop. In this list also, in this resubmission list also, the name of respondent number 4 was not present, was not included. Stop. Para. However, the respondent number 3 passed the impugn order dated 17 January 2023, appointing the respondent number 4 against the post vacated by Shri K. Vitoy Chishi.
Lordship,
Yes.
if I may.
Yes.
The letter dated 3rd January, where it states that respondent number 4 is not mentioned. In the petition, that document is incomplete. There are altogether 69 applicants were given, and respondent number 4 falls at serial number 63.
No, these are just submissions of the petitioner. In your affidavit, you have put the complete list. In that, he figures at serial number 63. However, respondent number 4 against the vacancy created by Shri K. Vitoichishi, MTS, Office of the District Horticulture Officer, Kohima. Stop. Being aggrieved, the petitioner has come before this court. Stop. It is the submission of the learned counsel for the petitioner that the appointment of the respondent number 4 is against the laid down procedure in office memorandum dated 22nd September 2004 and also the office memorandum. You have included both the memorandums, no?
Yes.
3rd March 22 also.
No, my lord.
Then just say office memorandum dated 22/9/2004. Stop.
3rd March 2022, I don't know if I.
Yes, okay. Learned counsel for the petitioner, referring to the meeting minutes of the special committee held on 17 January 2023, dated 17 January 2023, which is annexed as Annexure 3 to the affidavit of the state respondents, has submitted that the meeting minutes clearly state that regularization of in-service casual employees is to be done strictly on the basis of OM dated 22/9/2004. Stop. And the ratio of the existing vacant sanction posts shall stand at 8:9 for regularization and fresh appointment, and that regularization will be done strictly on the basis of seniority district-wise. Stop. In the Annexure A, accompanying this meeting minutes of 17/1/2023, the list of recommended casual employees for regularization shows that some districts have more than one work charge employee, more than one casual employee who has been regularized, whereas none has been regularized from Kohima district. Stop. The petitioner has also submitted that the post of MTS which fell vacant in the office of the District Horticulture Officer Kohima should have been allotted for regularization, and accordingly the petitioner should have been appointed against the said vacant post, being the senior most casual employee in the office of the District Horticulture Officer, Kohima. Stop. Next. The learned government advocate, Ms. A. Ayemi, by filing the affidavit in opposition, has stated that the special committee which was constituted to examine and consider the regularization of in-service employees and fresh appointments against 17 vacant grade 4 posts was constituted via circular number HR/ESTT-2/24/AR/2022 dated 10th January 2023. Stop. The committee had identified 17 vacant grade 4 posts all over Nagaland, and the department was in receipt of 69 applications from in-service employees for regularization, fresh applicants and compassionate ground applicants. Stop. The name of the respondent number 4 also figured at serial number 63 in the statement showing the applications. Stop. The special committee in its meeting on 17 January 2023 decided that regularization of in-service employees would be done strictly on the basis of the OM dated 22/9/2004, and the ratio of the 17 vacant sanction posts for regularization and fresh appointment was decided to be 8:9, i.e. 8 for regularization and 8 posts for regularization and 9 posts for fresh appointments. Stop. Learned Government Council submits that the vacant posts of MTS in the office of the District Horticulture Officer Kohima was identified for direct appointment. Stop. It is also submitted that the petitioner could not be accommodated for regularization within the 8 vacant posts meant for in-service employees, as the vacant post which arose in Kohima district was not identified for regularization. Stop. On the other hand, the respondent number 4 was appointed to the post of MTS in the office of the District Horticulture Officer Kohima, as this post was identified under the quota for fresh appointments for direct recruitment. Stop. It is therefore submitted that the petitioner cannot challenge the appointment of the respondent number 4, as it was done against the quota for direct recruitment. Stop. However, learned government advocate Ms. A. Ayemi has considered that the petitioner is the senior-most among the casual employees in the District Horticulture Office Kohima, and therefore can be considered for regularization as and when next vacancy arises. Stop. Para. Learned Counsel for the respondent number 4, Mr. Tongpok Ponganar, has also submitted that the petitioner does not have any locus standi to challenge the appointment of the respondent number 4, as he has been appointed against the direct recruitment quota and not against the regularization quota. Stop. Para. This court has considered the submissions of the parties, perused the pleadings, and is of the view that as per the office memorandum dated 22nd September 2004, 50% of regular vacancies is to be reserved for regularization of work charge employees, and the remaining 50% is to be filled up as per the normal rules of recruitment. Stop. Therefore, in pursuance of this OM of 22nd September 2004, the special committee had identified 17 vacant posts, out of which 8 posts were identified for, 8 posts were reserved for the regularization of existing in-service work charge / casual employees, and 9 posts were identified for direct recruitment. Stop. It is the discretion of the state respondents as to which posts are to be identified for direct recruitment and which posts are to be kept for regularization. Stop. It is not for this court to direct that certain posts should be reserved for regularization, and certain posts should be put up for direct recruitment. Stop. And therefore, this court is of the view that the petitioner has failed to make out the case, and the petition is dismissed. Stop. However, the state respondents are directed to consider the case of the petitioner as and when the next vacancy for regularization arises, as it is an admitted position that she is now at serial number 1 in the seniority list of work charge / casual employees in the office of the District Horticulture Office, Kohima. She is disposed. Done.